Hello, welcome. We should be ready to start in a couple of minutes. We'll just have some more people joining. All right, we're right at the top of the hour, and I think we should be good to start now. So, hello and welcome to the Calgary Public Library Foundation's Epilogue Society webinar. My name is Farai Tonzani, and I'm a Senior Development Officer at the Calgary Public Library Foundation. The Calgary Public Library Foundation is a nonprofit organization that serves the Calgary Public Library systems through inspiring donors to help enhance all the wonderful services and programs that are offered by the library. We've raised over $80 million to date, which has helped fund countless programs, new collections, and increased literacy in our community. And I'd like to begin today's event with a land acknowledgement. With gratitude, mutual respect, and reciprocity, we acknowledge the ancestral home, culture, and oral teachings of the Treaty 7 signatories, which includes the Siksika Nation, Piikani Nation, Kaurna Nation, the Ithka Stony Nakoda Nation, consisting of the Chiniki, the Bearspaw, and Good Stony bands, and people of the Tsuut'ina Nation. The city of Calgary is also homeland to the historic Northwest Métis and to the Otepimswag Métis government, Métis Nation Battle River Territory, Nose Hill Métis District 5, and Elbow Métis District 6. At the Calgary Public Library, we celebrate stories, the stories of the community and the land that we live on. We save the communities on Wichinspa, Gutinsi, and Mokinstas, which describes the gathering place where the Bow and Elbow rivers meet. We respect all people who share, celebrate, and care for the Treaty 7 territory of Southern Alberta, and we honor the original caretakers of the land who remind us of the ongoing histories that precede us. We recognize our shared responsibilities going forward to help bring everyone together on this journey of truth and reconciliation. So today we're joined by Craig Tervit, who was the founder of The Last Word. Born in South Africa before immigrating to Vancouver in 1995, Craig completed his undergraduate degree, a Bachelor of Arts in English and Political Science at the University of British Columbia. He fell in love with the city. He moved to Calgary in 2010 for the Combined Law MBA program at the University of Calgary. He fell in love with the city and has lived here ever since. Craig met his wife Jen in law school, and they now have three wonderful young daughters. Craig founded The Last Word in 2015 after realizing how much he loved to work one-on-one with clients to protect their families and plant their legacies. So before I hand you over to Craig, I just wanted to mention a few housekeeping items. We'll be recording this webinar, and you'll receive a link to the presentation in a few days' time so that you can use these resources far into the future. We'll leave time at the end of the presentation for a brief question and answer period. If you have questions for Craig or for myself and the foundation team, please write them in the Q&A box, which can be accessed by clicking the button on the bottom of your screen. Lastly, we would really appreciate if you would complete our short survey at the conclusion of the event. The survey will be shared on the screen and also in a follow-up email. If you complete this survey within the next week, you have a chance to win a pair of tickets to our upcoming Log Library game on Friday, September 26th. The survey allows you to let us know how the webinar was for you and to help us choose future topics for this webinar series. Now, I will introduce you to Craig from The Last Word. Thank you.
Thank you so much for really fantastic welcome, and it's looking forward to this. So I just wanted to say briefly, I was very excited to get the invite to do this presentation, and Farai mentioned that you can win tickets to the Locked Library. I'm a huge supporter of the library, and you know, weekly visits to our local library with the kids, and you know, I will actually be there for the Locked Library on the 23rd with my two oldest. They're very excited for it. So yeah, it's a great. They're really fun if you've never been. So you know, talking about estates, I'm just going to quickly share my screen so that you can see just a few slides. It's not tremendously dense. Okay. So when we're talking about, you know, this presentation, the role of the executor, I work in the estate world, so I deal with executors all the time. I deal with estate planning. You know, that's my day in, day out. It's sort of the language that I speak day to day. So with that said, the term executor gets thrown around quite commonly, and sometimes there's some confusions about what it means, who should be appointed, who can be, what happens when you do it. So the idea of this presentation is just to go through some of those basics from a fundamental level, and then sort of to build on a few things in terms of who you might want to name, benefits, downsides of doing that, and then also, you know, what you would do, you know, what considerations you should have of if you are actually named. So as I just mentioned, we'll go through the definition, who you should appoint, and what it means if you're named. So first of all, with the title of executor, in Alberta, that job is actually called a personal representative. Of course, you know, it seems like we've just tried to do things differently, and we're a little almost awkward in that way because everyone else uses the term executor. But in Alberta, we actually go with the term personal representative because it covers two roles that are roughly the same. In most places, you talk about an executor, and what it technically means is someone who is in charge of dealing with the estate when there's a will. If there's no will, then you're the administrator of the estate if you have the exact same job. In Alberta, we've kind of combined them together, and we've called it just universally personal representative, whether or not there's a will or not. If there is no will, the person who gets appointed is appointed by the courts. There's a sort of order of who has priority to be that. And if there is a will, then obviously whoever's named in the will has priority to proceed. So executors if there is a will, administrator is if there isn't. In Alberta, we just use the term personal representative. I'm going to use executor and personal representative fairly interchangeably in this presentation just because they're effectively the same thing, and people commonly use the term executor. It's easier to just go with. When we're talking about a personal representative or executor, what is that job? The primary thing is really to think about how the personal representative's job is to manage the estate, to administer the estate. The question there becomes, what is the estate? I have plenty of people who sort of get somewhat caught up and struggle with the concept because it's a little odd. The estate is sort of its own entity, but it also kind of isn't. There isn't a person who's the estate. There isn't you know, a place you can go and that's where the estate is. I always liken it a little bit to something like a corporation, where maybe you might own all the shares of a corporation and then think that you own the assets the corporation owns, but actually you just own the shares and then the corporation owns those assets. It's a little like that. The main thing is if you pass away, the things that you own are no longer owned by you because you're no longer alive. However, they haven't gone to someone else yet. So they're in this in between. And what that in between is really the estate. It's sort of like a legally created entity that exists until everything's debts are paid off and everything is passed on to whoever it's going to. Um, so when we're talking about the estate, that's kind of what it is. Um, Now, there's some things that don't really go into the estate. So if you have a joint asset with someone else, say you have a bank account where your name and their name is on the account, um, that won't be a part of the estate typically because if you die, your name comes off the account. Now they're the only owner. Similarly, if there's property that you own in a particular way that transfers when you pass away, called joint tenancy, same thing applies there. It wouldn't be in the estate because it transfers immediately on death. Essentially, once you're deceased, you're no longer one of the owners. The only other person on there is the owner. Um, it can be a little trickier than that, though, of course, because this is law. We always have to make things difficult. In that, if you name an adult child as a joint owner of an account or of a property, I see this frequently where someone will add their adult child onto the title to a property. Um, there's something called this is getting very deep into the legalese side, but something called a presumption of resulting trust. All you need to know about that is just that you need to be very clear as to what your intent is if you're adding an adult child of yours onto an account jointly or onto a property. Because quite frequently, the reason this is set up this way, quite frequently people would add their adult children onto an account, say, to help manage the account. And it wasn't actually intended that the account would go to them. It was just there to help them manage it. And so as a result, the legislation now says that unless there's anything clear indicating that you do intend that to transfer to that adult child, then even though they're a joint owner, it's still going to go through the estate. So, the big takeaway with that is just if you're an adult child and you're joint on an account that you're supposed to be receiving, make sure your parent puts something in writing, and vice versa. If you're adding someone onto your accounts or properties, just be absolutely clear about what you actually intend. Anyways, that was all to say. It's not as easy as it seems, but everything within the estate is typically all of your assets that aren't automatically transferring to someone else. And when we're talking about what an executor has to do, so if someone passes away, you find out that you are the executor. This is, the first thing is usually to see if there's a will, to find out, be certain that you are named as the executor or the administrator or something like that. Find out if you need to probate the will. That's the process of going through the courts, taking the will to the courts, indicating what assets, what debts there are, who the beneficiaries are, and getting the court to sign off on saying that based on the will and the will seems valid, this is how things should go. And then usually someplace like a bank, particularly land titles, are able to transfer assets with that court order, whereas they typically won't with just a will. So probate is sort of a necessary part of the process. In terms of taxes, the executor is always in charge of making sure that all the taxes are paid before beneficiaries get paid, or if the taxes haven't been paid, the executor can be liable for making sure they're paid. Protecting the assets. So, if you find out you're the executor and someone's passed away, you need to secure those assets as quickly as possible and, within reasonable bounds. But, you can't sort of leave everything for a year or two. And if things are stolen, but you left them out somewhere and it was easy for them to be stolen, that's a concern. That's still your issue because you're in charge. Similarly, dealing with debts, making sure that the debts are valid debts, we talked about taxes already, but those are quite frequently something that can come back to affect an estate more significantly than someone initially thinks. If maybe the last 5, 10 years of taxes haven't been filed, you get it all caught up, and it turns out that there's also a huge tax bill owing. Um, the executor has to stay on top of that. I will clarify in terms of that. People are frequently worried when they're acting as executor um, about what if there's not enough money in the estate? Am I going to be responsible for paying any difference? Like if there's more taxes than there are assets owing, then what happens? The executor is not liable for paying those unless they do something that they shouldn't, in terms of if you pay out a big chunk of money to beneficiaries and then afterwards it turns out there's not enough money left over after that to pay the taxes, then you're in trouble. But if you follow the steps correctly, and you pay out all of the debts and taxes and things like that before you pay things out to beneficiaries, then it's not your issue if there isn't enough money in the estate to cover those all of the debts or anything like that. The last thing to mention about an executor's duties is dealing with claims on the estate. So, a claim can be a debt, like if someone comes out of the woodwork, Uncle Jim says, hey, I was actually owed $50,000 or something like that. It can be that. However, claims can also take the form of maybe a claim that there was a new will, maybe a claim that they didn't know what they were, they didn't know what they were signing when they signed the will, or someone forced them to sign it. Similarly, claims can also be if someone leaves everything to, a new partner and doesn't provide for their minor child. That can be a claim on the estate on behalf of that child to say, you had responsibilities during your lifetime. You didn't actually meet those by not providing for this dependent of yours. And so there can be a claim on the estate to say that you still have to provide for those dependents of yours that are still dependent on you and were relying on getting something from the estate. All of those are involved in what the executor needs to do. There's a lot for sure, and it's not a job that I typically tell people if they're worried about maybe naming up between their kids. How do we decide? What if one of them's upset? Usually, once someone starts doing the work and everyone is of the understanding of what's involved, the ones who aren't named as executors are usually thrilled. Or if they're not, it's usually because they don't really understand the amount of work involved. Okay, executor versus trustee. Sometimes these terms are used interchangeably. A trustee is usually the person who's in charge of a trust, which seems probably fairly obvious. But a trust operates a bit like an estate, but you can set up a trust for the benefit of someone, even if you're still alive. You can put money aside, put it in trust for that person, and you can put money in trust for yourself as well. All a trust is essentially an asset being held by one party for the benefit of someone else. And so typically, there's lots of benefits for trusts, lots of downsides as well. When we see them in an estate, it's usually where there's either a minor child or a child who's in their early 20s or something like that, where we don't really want them to get $1 million or something like that. So it's where we'll name a trusted family member or individual of some type to be in charge of that child's money until they attain a certain age, typically. And the trustee can have pretty broad discretion to pay for various things that the child needs, usually anything required for school, medical care, even, sometimes to the extent of payments for if they want to start a business when they're in their early 20s, or if they want a down payment on a house. The discretion you provide in a will can vary. And if you're named as trustee, the important thing there is just to make sure you're getting really, really good advice, because you have a very, very strong fiduciary duty, both as a trustee and as an executor. And they might be the same role. You might get both in the same circumstance, but your fiduciary duty means that if you do anything offside, or even where you should have gotten advice, but you didn't, but you thought you were doing the right thing, but you weren't, that can still be a really significant issue, and you can be personally liable for any sort of funds that have gone in the wrong direction or actions that should have been taken and weren't, that kind of thing. Um, there's no conflict if you are named in both of those roles. If you're the executor of a will and you're the trustee of the kids' trusts, in the same document, you can do both roles, and quite frequently, if you're someone who's responsible enough where you can be appointed as the executor, quite frequently they're comfortable naming you as the trustee as well. So quite often it is the same person. Um, uh, if they're separate people, there can be a conflict sometimes where the trustee, has a personality conflict with the other one, but there's no innate conflict there. So quite often, if people do name separate people, it's because maybe they're naming a parent as the executor, um, but they don't, and if they have small children, they're not thinking that the parent would be in a good position to be the trustee for the next 20 something years until the child is old enough. So they might assign the executor role to someone in their 60s or 70s, but the trustee role to someone who's younger because they're anticipating how long that trust would have to be in place. So if you're thinking about your will and you're thinking, who do I appoint as the executor / personal representative? There's a few things to consider. So number one, uh, location is important. I don't think it's the only important thing, but if they're located in Canada, that's at least one hurdle path. Tax filings, a lot of complications. There can be additional taxes. More often than not, it's not the additional taxes, it's the cost of hiring an international tax lawyer or international tax accountant, which can sometimes be $800 plus per hour. Those people are very specialized, very good at what they do, but if you can avoid that scenario, I always strongly advise it. We usually, it's the absolute last resort to name someone who's out of the country. And there's other options. So typically that's something that prevents someone from being appointed in that role. More specifically, beyond just Canada, if you have an executor or a trustee who's resident outside of Alberta, then the courts typically require, when you're getting probate, they typically require that that executor puts up a bond in order to be able to act. So what that means is putting up some security to protect the asset, because if they're outside, and by assets, sorry, I mean to protect the estate value, because if they're outside of the province, if they turn and run with the money, it's harder to track them down, enforce things, because it's not just within the law of the province. You've got to go outside of it. So typically, additional security is required if it is outside, if they are resident outside of the province. If the beneficiaries are all adults and can sign for themselves, can say that they're happy to waive the requirement for the bond. But typically, if there's a minor, there's no way that you can do that. So bond fees don't add up to that much relative to the cost of naming the wrong person. I always say, if it's sort of 0.5% of the estate, that's still a lot of money, or can be. But if you name the completely wrong person because they're in Alberta, they can do a lot worse damage than that. So it's something to consider and sort of discuss with your lawyer, with the beneficiaries, etc., just to make sure that you're not causing difficulties one way or another. Quite often, people will name a family member, typically, a sibling or maybe a parent. That's very common. It doesn't necessarily mean it's a good option. It can definitely be a good option, but I always think naming someone who has the wrong skill set or just doesn't really meet the skills needed, um, just because you trust them and they're a sibling, that's not really what you want to do. And also, similarly, parents sometimes want to name kids uh, just so that they can show that, just so the kid doesn't feel upset. Um, and that's not a good way to decide an executor either. Just because you name the wrong person, then everyone's upset with them because they're not doing a good job. All of the beneficiaries pile on. They think that even if the executor is doing the right thing, if they're not properly communicative, it can lead to everyone feeling suspicious, lead to hostilities, litigation at worst. And so you really don't want that kind of thing. More important to name someone who's the right person for the job that you trust, but having that right person is more important than if they're family, at least in my mind. When, and dynamics are important. If you're naming someone to sort of hold all the purse strings and deal with everything, but there is some already existing hostilities between siblings and you're naming one of them, it can really exacerbate things. I do frequently see clients saying, well, what if we just name them jointly? Then they'll have to agree on everything, no one's left out of the decision-making process. That should help. Unfortunately, that can go the other way too, where they just can't agree on things. I had a file once where it wasn't a will I wrote, but four sisters were all named jointly, and they all barely spoke to each other. Um, and we did our best to try and get them to come to an agreement on things. Unfortunately, it was a fairly simple estate, should have been dealt with from our end within a month or two. It took about a year and a half, and after that, they went to go fight it out in litigation, as far as I know. And it was just they couldn't all agree on the same things, and none of them trusted each other. But when you're joint like that, you all have to agree to do it, to take any step. And it can really, four people joint is probably never advisable. Two joint can be okay with the right dynamics, but it does carry that risk of what if the relationship doesn't, isn't well suited for them to work together for that kind of thing. They don't have to be best friends if they're joint. They just have to be able to work together and see what's important. Make a decision that's in their best interests, but also for the greater good of all the beneficiaries. Quite commonly, when we're dealing with a circumstance, especially where there's maybe some family disagreements, or maybe there's a circumstance where if someone, especially if a family is maybe new immigrants to Canada, or even from the other side of the country, it doesn't have to be in Canada, if they don't have close people around them that they feel like they might have good friends, but they don't have people that they really want to trust for this kind of role. It can be tricky if you don't have family here. And so one of the options that we frequently discuss is the idea of having a trust company involved. So that most of the bigger banks do have associated trust companies. So, they each have, it's not within the bank, but they usually have a separate company that is still connected to them. And they do a good job of what they're doing. I usually recommend them for almost everything except for the fact that they can be quite pricey. So as long as, it depends on what the priorities are, how much money there is, what the cost will be, but they are always an option to consider, especially if it's as a sort of alternate option to a primary person that you're naming, or if there isn't someone who's well suited to take on the job. Again, just kind of like we were talking about with the potential for a bond and paying the extra fee for that, having someone take it over, even if they're kind of, if it feels like they're pricey, the fact that they will do a good job and have it managed properly, they do that work all the time, can take a lot of stress off of everyone and can be well worth it, especially compared to potentially naming someone who has never done it before and doesn't know what they're doing. The important thing with an individual that you're naming, so speaking to the sort of personalities of who you want to name as the executor is that you name someone who can, I always say this job is a bit like being a project manager. So they have to understand enough to know the broad scope of what they're doing, but most of the specific work will be done by professionals. So they have to be able to talk to a lawyer, an accountant, someone at the bank. If they're selling a property, then to a realtor, to those different those different roles, and then also speak to the other beneficiaries to keep them informed as to what's going on. So a lot of communication, a lot of sort of running things, following up with different professionals and communicating with them, but also deferring to those professionals typically. Sometimes the person who's the smartest person in the room is not always the best for this because they feel like they know better than everyone what to do, and they can take on too much by trying to save money for the estate by doing it all themselves. That can work sometimes, but sometimes that's where people can get unstuck because they're trying to do too much and they're not protecting themselves by getting proper advice. You want someone who's responsible, keeps good records, isn't a huge risk taker typically. Someone who is proactive and will get things done and communicate. Okay, executor fees. When we were talking about the hiring a trust company to do this role, we talked about the cost of hiring one. One of the things I always mention in terms of that is that it's quite possible that if you name your sibling, for example, as the executor, that they may take an executor fee that is roughly equivalent to what a trust company would have charged. You can name in your will exactly how much the executor is going to get. Quite commonly, this is not identified in a will, and usually there's a sort of range that is typically associated with being the executor, and the executor would put that number forth, say, hey, here's all the work I've done, here's everything that's been dealt with the estate, here's what I'm proposing. Usually it's a percentage of the estate, usually somewhere between 1 and 5%. 1 would be quite low, 5 would be quite high. It varies a bit based on the size of the estate too, right? Like 5% of a $10 million estate is a tremendous amount of money. That would typically be a lower percentage for something like that, but it might be 5% of a $100,000 estate. The executor would typically, if there isn't a specific amount named in the will, then the executor would propose their fee to the beneficiaries who'd have to sign off on it. And if they don't all agree, then it goes to a judge who helps sort of determine what a reasonable fee is. You can also put in your will something that says that there's no executor fee whatsoever. But keep in mind when you do that, that executor fees, that an executor doesn't have to act if they don't want to. So if you're naming someone to do all this work and you're saying they don't get paid anything, hopefully there's someone who is, very close with you and believes that all the money should go to your kids, for example, regardless of the amount of work required by them. Because otherwise they might just say, no, thanks, don't want to take that on. And then there's no one to actually act in that role. So keep that in mind. The last thing to mention is just executor fees per the CRA are income for work done. So, it's a job. So you will be taxed accordingly. So sometimes people feel generous and they say, well, I want my executor to get, X amount of money for acting as executor, and I want that to be in the will. The downside is that if that is paid for them acting in that role, it's going to be taxed, at their rates. So keep in mind that, if you're maybe giving everything to 2 kids and naming one of them as the executor, if you're giving one of them, let's say, $100,000 executor fee, and then the rest is getting split between the kids, that $100,000 is actually going to mean that the executor, after taxes, may get barely more than $50,000, and then the other 50 is going towards taxes. Whereas if everything was just gifted to the kids with no executor fee, they'd be splitting it all 50-50, and no money would go towards taxes because you don't actually get taxed on estate gift. So it can be, you want to make sure that the executor does get compensation for what they do, and that is fair, but at the same time, having additional funds go to the CRA just to show that the executor got paid for their job is also maybe not what you want. There can be a bit of a complex discussion about how to put this all together, but it's something to consider. It's just that a large executor fee isn't always the best way to go, and isn't always the best for the beneficiary. Okay, so if you're named as an executor, um, the important thing to note is, as I mentioned just a few minutes ago, you can renounce. You don't have to take on that job. So that's something to consider first and foremost, is that just because you're named doesn't mean you have to take it on. Consider who else is maybe a backup to you, and consider if you're able to do it. Because once you take it on, it's harder to turn around and say, no, I don't want to do it anymore. You can't do it for 6 months and then just say, no, thanks, and then someone else will take over. There's a more of a formal process to get discharged as executor, someone else to take over. You have to sort of account for all of your actions, et cetera, et cetera. And part of that is just because they want to make sure that you haven't done anything untoward while you've been acting in that role. You take on significant liability if you're acting as the executor, because you, again, have that fiduciary responsibility to do what is in the best interests of the estate and what is in the best interests of the beneficiaries. So, if you leave things in investments when you really shouldn't have and you should have liquidated them, there can be beneficiaries that make a claim to say, well, the stock market went down and, things were invested, even if it was what was, the investments when the person passed away. If you leave them in those investments for too long after they've passed away, if they're risky investments, the beneficiaries may have a claim to say, well, you should have changed it. You should have pulled them out, put them in a bank account, or put them at least in more conservative investments to protect them. And even though you don't control the market, you should have hedged that risk a bit better. And to that point, that's why my comment about having someone who feels like they know best and you sort of won't listen to professional advice can be an issue, because the executor does tend to somewhat protect themselves by saying, hey, look, we talked to an investment advisor and that person said that these were good investments for the scenario that we're dealing with. I followed that advice. That will help protect the executor. Ultimately, it's their decision, but if they can show that they've done things in a reasonable way, even if the end result isn't what you would hope it to be, as long as they're acting reasonably and doing, being responsible, then they're usually okay to protect themselves that way. Similarly, if they get the advice of a lawyer and the lawyer says to do X, Y, and Z, that is A, going to mean that they're hopefully making good decisions, but also B, mean that they can defend those actions by saying, here's where I was told that this is what I should be doing, and that's what I did. One of those things that I tend to recommend to my clients when they're acting as executor is always to get releases from the beneficiaries before they provide the funds at the end of the day. So the release just says, here's all the accounting details. Let us know if you need anything more. Here's what we're charging as an executor fee. Here's, basically everything that was done on the estate. And you're going to sign off on saying you approve of all of that and you're not going to sue. And that way, the beneficiary gets a check and you as the executor get that release that says, okay, months from now, they're not going to turn around and sue despite the fact that they got all the money that they were supposed to get. Similarly, one of the things we make sure that the executor does is file all the taxes, get a clear sense of what the taxes are before distributing the estate. Maybe they do a small distribution beforehand, but getting a final tax clearance certificate is something that the CRA offers, which is just to say that they won't turn around and reassess something from 5 years ago and then say, pay up now, even after you've maybe dispersed all the money from the estate. And then really, the last important thing, if you're named as an executor in someone's will, and they're still alive, and they're asking you, hey, will you be the executor, or that you're named in their documents, is just to make sure that their documents are clear. The executors end up in a lot of difficult scenarios because they've said yes to help and do this role of executor, but the document that they're supposed to follow, the will, is unclear or sets up some sort of fight between people because language in some way suggests one thing and another thing, or maybe the instructions in the will don't actually match with the assets that are there. These are the kinds of things that lead to legal problems, which leads to the executor having a bit of a nightmare scenario to try and deal with. So if you're named as executor in something, wherever possible, try and get a copy of that document and just have someone look at it for you. But even if not, just ensure that it's done with a professional who actually knows what they're doing. And keep in mind again that ability to renounce. So if you are named in a document and it's not done properly, don't just take it on just because you feel like you need to. Especially if it's going to land you in a lot of legal trouble and financial difficulties if you're getting sued because of complications due to the way it's set up. So there's a lot involved, and don't take it on lightly. Give it some consideration before you say yes. And that is about it for my presentation.
Thank you very much for your presentation, Craig. I personally learned a lot, and it's definitely going to help me as I'm dealing with my own affairs. So thank you so much for the insights and the expertise. And while you were speaking, we had a few questions that were coming up in the Q&A. So maybe we can jump right into those and see how many we can cover.
Absolutely.
All right. So you touched a bit on this, but there's a question about whether you would recommend to have multiple executors, and also how long does the executor role actually last?
Okay, so multiple executors, I think, just depends a bit on what you mean by that. So I do always recommend that people name backups to the people they're naming. Whenever we're writing a will, we want to make sure that it is fairly future-proofed, just because we're not expecting people to update their wills, once a year or anything like that. So typically for every role that we have in there, whether it's the executor, a trustee, guardian for your kids, anything like that, we typically want you to name one person and then a backup to that person and probably even a backup to that person, just in case the first person can't do it, or like we just talked about renouncing, if they say no, I don't have the ability to take this on right now. So you might be naming multiple executors that way. If the question is more around naming multiple executors jointly at the same time, I pretty much covered that in the presentation. I usually advise against it unless it's, two jointly at most, and also if it makes sense given their relationship dynamic, given where they're located, their ability to both sign off on everything together. Keep in mind that it might cause problems, and so it needs to be in a very specific situation where it won't cause those issues.
All right, great.
Oh, and sorry, what was the second part of the question? Oh, I think that was it, right?
Yeah, the second part was how long does the executor
Oh, yes.
last?
So it can vary. So the executor, if you're not the trustee for a trust as well, usually it's getting probate, which may take a few months. And then after that, it's whatever time it takes to administer the estate. Sometimes I've seen these completed as quickly as 6 to 8 months. Typically, it's between a year and 2 years. Sometimes, especially when there's fighting and the things don't get dealt with quickly, it can lag on for a very extended period of time.
All right.
But usually, most estates are done within about 2 years.
Okay, great. Let me see what else we have here. What resources or help can an executor get during the process? How can I make things easier for my executor? So like they give an example of like maybe documents, sharing passwords, things like that.
Yeah. Okay. So the most helpful things for an executor is to know where the will is. They don't necessarily have to have a copy of the will, but knowing where it is and that they're named as executor is probably first and foremost the most important thing. After that, you know, documents that are helpful would be, I usually suggest putting with the will, any sort of life insurance policies, if as long as you're okay with your executor seeing them. You know, a brief document maybe explaining where you bank, but you wouldn't put all of the banking information there or passwords or anything like that because you want the will to be somewhere where the executor can find it fairly easily. Like a common thought and a reasonable one is where people think, okay, well, I'll just put the will in a safety deposit box, and that's great because it's secure. But if someone is named as the executor and they know they're named and the will is in the safety deposit box, they actually need the will to get into the safety deposit box. So it can get really tricky. And it's, you know, I've had circumstances before where, you know, I've had to attend at the bank with a few other people from various different, you know, who represent different people, as well as the bank representatives. And then we open the safety deposit box to see if the will's there. If it's there, then, and it says that the person who I represent is the executor, we're okay. And if it's not, then it goes right back in and, you know, we have to sign non-disclosure and all these kinds of things. So you don't want a scenario like that. Usually you just want to put it somewhere that is, you know, put away, like usually in something like a filing cabinet at home is usually fine. It doesn't typically have any value to anyone other than yourself and your beneficiaries. Like it's not worth stealing for someone. Or if you're putting it in a safety deposit box, then make sure that a copy is provided to someone else so that they can use that copy to help access the safety deposit box. In terms of the documents, I know I'm circling around to this. You don't want to, if you're leaving it in just a filing cabinet at home, you don't want your passwords in something like that, because if someone breaks into your house and gets access to that, then, you know, not only have they stolen whatever they've stolen from your house, they can also clean out your accounts. In terms of passwords, I usually recommend using something like a password manager. This is, you know, there's a few different ones that are quite secure, where you can store all of your passwords in one sort of thing, and that is, and it's very secure. And the important thing there is that then you can usually name a legacy contact where if they prove that you've passed away, then access to that will be provided, but it is secure and it's not something where you just hand the password over to someone else.
Okay, great. How do trust companies establish their fees?
So the good news is they're quite upfront with them. If you decide you want to work with a trust company or you're interested in working with one, you usually meet with them and they provide you a sort of fee agreement that you'll be working with them. Now, nothing has to get paid until you pass away. So if you name them and then you later on change your mind and name someone else, you don't have to pay anything. You only pay, your estate would pay the fees. And those fee agreements, they want to make sure that they get paid. So it is actually incorporated into the will by reference. So it'll be a document that you sign before you sign the will. And then in the will, it says the fee agreement that we've signed is included, and that's what they'll get paid. Their fees tend to be, you know, across the trust companies, it's usually a formula with percentages. So typically in the range of 4 to 5% on the first million in value, then 3% on the next, 2% on the next, that kind of sort of lowering percentage as the estate gets bigger. But that's typically the sort of type of structure for their fee agreements.
Okay. All right. This next one, I think I can take. It says, I'm considering leaving a gift for a charitable organization in my gift will. Should I let the charity know that I'm doing so in the amount? And I would say yes, absolutely. this will give you a chance to connect with the charity, and it also allows the charity to be able to thank you and celebrate you while you're still alive. So, absolutely, I would say let the charity know if you're leaving a gift for them in your will or if you've considered doing it. Feel free to reach out to the charity. I don't know if you have anything to add on that one, Craig.
Yeah, it's not legally required, but I agree with you that, for all of the things that, if you're doing something like that that does benefit a charity, they want to have the ability to thank you and connect with you because you're valuable to them, like as a person, not just as a donor in that capacity. And having that benefit of maybe even a closer connection with that charity. Can be nice. There's usually not much of a reason not to. If you change your will after you've told them that you've named them, you don't. It's not that you'd have to go and then tell them. So you don't have to feel like telling them is an obligation for your lifetime that you've told them, and now this has to be in your will. But they do want to connect with you because if it's important to you, then they want to connect with you and sometimes show the sort of work that they're doing more extensively.
Yeah, I completely agree. We have a number of questions about executors who are out of province. So I'll just summarize a bit. There's a question about just your general thought on it, and you touched on that a bit. And then the other question is, what is your opinion of having an executor and a co-executor who are out of province, or one is within province and one is out of province? So just the dynamics of having the executors
For
not
sure.
necessarily being around. Yeah.
So, one reason why sometimes people want to appoint co-executors is that, and that's, acting jointly, co-executors, same thing, is that requirement, I sort of gave a simplified version of it because all of this stuff can get more complicated at any point. There's a lot to it. But if you're naming joint executors, you can get around that bond requirement if one is in Alberta and one is outside of. Because actually, the requirement for the bond for the estate is that 50%. Sorry, for the bond, the requirement is that at least one of the executors is resident in Alberta. So, if you name someone in BC who you'd like to really be the one running things, and then maybe you have someone local who can be involved and would be able to deal with things, but you're worried about that requirement. You can choose to name them jointly, and then it would be the case that no bond would be required there because there'd be someone in Alberta who would be accessible and they're resident here. So that is something that can certainly be done. It can make it tricky for the executors to sort of manage things. If one's in BC, for example, and one's in Calgary, just because they both have to sign off on the legal documentation. So it means there's a bit more back and forth, not just for the probate, but similarly, they both have to sign off on selling a property. They both have to sign off on CRA documents, those kinds of things. But if in some circumstances, it can work really well to help avoid that. Sorry, the requirement for a bond.
Okay. All right. And then can you get around the executor fee being taxed by giving them a larger gift within the estate? Or is there any other way to handle it?
Yeah, so the larger gift within the estate is certainly possible. Keep in mind, though, that you know, if you're giving someone a gift, let's say you have two children, older daughter, younger son, just for the sake of this, and older daughters who you want to name as the executor, and you don't, you realize that if it's split 50-50, you know, with no fee, then she's probably getting about the same amount as she would get if you gave an executor fee to her, and then it doesn't really affect things significantly for her. It would just mean less for your son because that's going to the CRA. So if in that circumstance you say, okay, well, she's going to get $50,000 and then the rest is split 50-50 and no executor fee. That can work fine, except if she renounces as the executor and then maybe her brother's the executor, she's still getting 50 grand plus half of the estate. And now the brother is doing it and he's not getting a fee at all. So, and similarly, like if we try and get around that by saying, oh, okay, well, this is a gift that is conditional on them acting as the executor, the CRA is going to look at that and most likely determine that that's actually just payment for acting as the executor. It's not a gift. So, it can be done, but just keep in mind that if you're doing this, you should be comfortable with the result of what if they don't act as the executor.
Yeah. Okay. I think maybe we can take a couple more. The next one, should the executor also be the manager of your personal directive? Will the trust company do this?
Yes. So,
Yeah.
your personal directive is a document that indicates who is in charge of your personal decisions, hence the name. But
Yeah.
what that means is if you are incapacitated, so you can't make decisions for yourself, but you are still alive, then who is deciding medical decisions? Who's deciding where you can live? Who can visit you? Activities you're involved in? All of those kinds of decisions. So that one can be the same person, but it certainly doesn't need to be. And quite frequently they're different just because they can be different skill sets. So typically, I always say the person that you're naming in the personal directive should know you really well, should know what your values are, what's important to you, know how to make a medical decision on your behalf, and also have a temperament where they can advocate for you. There's some people who might care very deeply and might know exactly what you need, but if they're dealing with a care provider who's not doing a good job, they're just not the personality to go in and, ask a bunch of difficult questions and make things difficult in a good way to sort of represent you. So, with that said, that person can be the same person. It could be that the person who's really close to you and knows you very well, and would do that for you is also the person who's responsible and able to act as the executor. In terms of a trust company, they don't act as personal as the agent in your personal directive, just because it's really hard for them to make those kinds of determinations. They have to. They're an organization rather than an individual, so it's hard for them to know what you would want, and that's usually best suited to someone who is a friend, family member, something like that.
Yeah. Okay, I think we'll take one more. This has been appearing in a lot of questions, and this is related to probate. So I'll just read several that are quite related, and I guess you can pick a theme from there. So
Sure.
one says, is there a way to avoid probate? Another one says, do all wills have to be probated? And then the third one is, what is the timing for probate?
Okay.
So,
Yeah.
yeah,
No, those all sort of interrelate. So,
yeah,
maybe a first point to sort of address on that is, probate, when we're asking about avoiding probate, eh, there's a few reasons why people say that they need to avoid probate. One is because of how long it takes. So to address the comment about how long probate takes, if we're talking about the time it takes to just get the probate order from the courts, which is, just to officially be able to deal with the estate, you can usually do that with the will beforehand, but you can't take some of the steps. You can't sell a house. You can't do things like that. That part, if everything is done properly in the will, now there's a digital system. You can usually do it within about a month. It doesn't take that long. If you have to go through if there's additional complications, it can take a bit longer, maybe 3 or 4 months. And then obviously, if there's a significant issue where it has to go through the courts, either because people are fighting over it or because, things were done incorrectly on the will or something unexpected has happened that has to get dealt with by a judge, that can extend how long it takes. But usually that specific probate part of getting probate, which is, in order to sell properties, etc. Somewhere between 1 and 4 months, I'd say, which isn't that long in the grand scheme of things. The other reason people say that they're trying to avoid probate is usually because they're worried about the cost of doing so. And probate is something where, there's the cost through the courts. And quite often, when people have heard that probate's so expensive, it's usually based on somewhere other than Alberta. In other provinces, probate fees can be up to 1.5% of the estate, which is a lot of money. In Alberta, that number caps out at $525. So, I always say it's the cheapest place to die in Canada. So, it's, maybe not quite so terrible a thing. You see lots about avoiding probate online, certainly, but usually is not specific to Alberta. And there are other reasons why you might want to avoid probate, but keep in mind that probate is a way of making sure that the right things are done and the right people are notified. If you're the executor and you're trying to avoid probate, you're kind of opening yourself up to maybe being sued down the road, because there's a timer that starts once probate is granted, whereby someone has 6 months from when probate is granted to contest the will. And if they don't do that, and you disperse all the funds, properly, then you as the executor are off the hook, even if they find out that, oh, actually things were done, I have an issue with the will or something like that. But that's because you went through that court process. If you don't go through probate and you disperse everything, that timer never starts. So you are never really fully off the hook. So there's certainly some times where we want to make sure we avoid probate, just because the value of the estate is so low. If the whole estate is worth $5,000, then it makes no sense to do probate, especially because in addition to the court fees that I mentioned, which again, not all that much, there are legal fees. So, paying for a lawyer, a few $1,000s up to, significantly more than that, depending on complexity, those kinds of things. But, for a reasonable size of estate, usually probate is not something that you're trying to avoid too much, because it does offer a lot of benefits as well. To avoid probate, you just have to make sure that everything is transferring outside of the estate. You can usually get away with, if there's a bank account in the deceased's name worth $5,000 or something like that, and everything else is joint or names a beneficiary, and if there's a will that is very officially written, looks perfect from the bank's perspective, they'll usually allow the executor to sort of manage that, but not much more than that kind of value. Like they're taking on liability by not going according to a probate order from the courts. So they're not inclined to sort of extend more generosity that way, I guess.
All right. We are a little bit over time, so I think we stop here for the Q&A session. There are a lot of questions that came through. I couldn't get to all of them. So for anyone who still has a question, please feel free to reach out to Craig or to myself directly. You can see the contact information on the screen. Then I'll end by just saying, leaving a gift in your will is one of the most meaningful and impactful ways that you can support the charities that you love, including the Calgary Public Library. These generous gifts enable the library to plan for future and to meet the ever-changing community needs. So if you're interested in learning more about the impact you can have by leaving a gift in your will to the Calgary Public Library Foundation, I'll be pleased to connect with you. Again, my contact details are just on the screen. And if you're already planning on supporting the library in your will, please also let us know so we can properly thank you, celebrate you, and ensure that we can fulfill your wishes and welcome you to the Epilogue Society. I'll also be following up to share the webinar survey that I spoke about and the webinar itself. And as a quick reminder, we have a pair of tickets to our upcoming Log Library on Friday to give away. So please complete the survey for your chance to win and to share the future topics that you'd want us to discuss. You see the link shared in the chat on the screen, and you'll also receive it shortly in the email. So again, thank you, Craig. Thank you so much for being with us today and for sharing
Thanks,
your
Farai.
expertise. Yeah, and thank you to everyone for attending. It was so heartwarming to see such a wonderful turnout. Thank you for supporting the library and for your support to the Library Foundation. Have a lovely afternoon.
Thank you.
All right.